In this video, we're going to talk about USCIS new policy updates to protect some many immigrants, but visa backlogs continue to cause hardships.
Visit our Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
In an announcement, U.S. Citizenship and Immigration Services, USCIS, clarified an earlier policy change intended to increase green card eligibility under the Child Status Protection Act, CSPA, for kids who aged out as a result of the protracted visa backlogs. Understanding the function of the CSPA and the revised interpretation that USCIS revealed earlier this year is crucial before delving into the new update. The 2002 law safeguards non-citizens who, at the time their parents' family or employment-based preference category visa petitions were filed, were still regarded as children, i.e., unmarried and under 21 years old, but who, as a result of the time it took the government to decide the petition, had turned 21 years old and were no longer qualified to receive an immigrant visa. The CSPA functions by freezing a child's age according to a formula. The biological age of the non-citizen kid at the time their visa becomes available is computed, and any processing time associated with the petition is deducted to arrive at the CSPA age. When a visa becomes available for the CSPA age calculation is not specified in either the statute or the rules. Within a year of the immigrant visa becoming available, beneficiaries must also have sought to acquire lawful permanent resident status. The CSPA age calculation and the sought to acquire criterion were both based on a single chart that was issued by the Department of State, DOS, prior to 2015. In that year, the DOS started to release two charts, the Final Action Dates chart and the Dates for Filing chart, which tell beneficiaries when they can start submitting the necessary paperwork for their immigrant visa applications. Due to this modification, applicants were no longer required to wait until their visas could be issued before having their applications processed. Similar to this, USCIS utilizes these tables to decide when to accept and start processing adjustment of status applications for beneficiaries of the preference category in the United States. USCIS assesses whether there are more available immigrant visas for the fiscal year than there are known applicants each month. Beneficiaries must use the Final Action Dates chart unless they are permitted to use the Dates for Filing chart in that case. In 2018, USCIS made the decision to calculate CSPA age using the Final Action Dates chart while enabling beneficiaries to submit their petitions for adjustment of status using the Dates for Filing chart. This meant that even though a non-citizen paid the cost and submitted their application using the Dates for Filing chart, because their CSPA age calculation was based on the later occurring Final Action Dates chart, they may eventually age out and lose their eligibility for adjustment. USCIS amended this policy, in spite of criticism and largely as a result of a lawsuit filed on behalf of documented dreamers who had aged out according to the 2018 guidelines. As of right now, the organization would take into account an immigrant visa becoming available for the CSPA age computation at the same time as it took into account an immigrant visa becoming instantly accessible for accepting and processing the adjustment of status application. The update also mentioned that applications that have already been denied can be reopened by submitting a request to reopen, and the 30-day filing limit for such a move may be waived if the delay was reasonable and out of the non-citizen's control. The change, albeit welcomed, raised a lot of questions, particularly for those who were unable to register their modifications and, as a result, were unable to satisfy the requirement that they have tried to obtain lawful permanent resident status within 1 year. For instance, some non-citizens might not have filed an application under the Dates for Filing chart because they chose to wait for their priority date to become current under the Final Action Dates chart rather than fork over the costs in the face of uncertainty. Others may have aged out and never filed, or they may have applied but had their application denied by USCIS because their CSPA age was over 21 under the old guidelines, while waiting for their priority dates to become current on the final action dates chart. Additionally, the February policy change by USCIS omitted to explain how the new rule would apply to non-citizens with outstanding applications who matched the CSPA age interpretation in the earlier guidance. To resolve these issues, USCIS amended its policy manual on August 24, 2023. In particular, USCIS viewed the policy change on February 14, 2023 as an extraordinary circumstance that might be used to excuse the 1-year sought-to-acquire requirement. USCIS made it clear that individuals who choose not to apply because their CSPA age could not be determined or was over 21 years old under the previous guidelines might be qualified for the CSPA's age-out protection. Additionally, any application that is now ongoing and was submitted in accordance with the previous guidance will be deemed to have met the 1-year sought-to-acquire criterion. Unfortunately, despite USCIS's commendable efforts to give non-citizen children in the U.S. assurances about their CSPA age, the DOS has not yet changed its recommendations. The final action dates table is still utilized for CSPA age estimates, according to the Foreign Affairs Manual, which oversees consular processing cases and directs consular employees who decide on visas for foreign applicants. The kids who are rendered ineligible for an immigrant visa because they age out under this more stringent interpretation suffer as a result, which not only generates confusion but also causes suffering. The ever-expanding visa backlog, though, is the bigger problem. A revision in the dates for filing table would prevent over 250,000 documented dreamers from aging out of their dependent visas and from becoming derivatives on their parents' green card petitions. These young people must find another method to stay, or else they will be forced to leave the country. For the most part, the Biden administration has done its best to mitigate the harm brought on by the visa backlog. For instance, it launched a new Family Reunification Parole (FRP) program in July for American citizens and lawful permanent residents with relatives living in Colombia, El Salvador, Guatemala, and Honduras and who have I-130 petitions that have been accepted. These family members might enter the country on parole if they were invited to take part and wait there while their visas were being processed. The administration also unveiled plans to update the previously existing FRP programs for Haitians and Cubans in August. There are also a number of bipartisan bills that are currently before Congress that seek to relieve the backlogs of applications for both family and employment-based preference categories of visas and that explicitly help documented dreamers by giving them a road to citizenship. Although the system now operates more fairly as a result of recent USCIS adjustments, this isn't a permanent solution. It is obvious that Congress must take action to implement more significant structural improvements to safeguard these immigrant youngsters.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!